Hi again, everybody. My name is Karen. I work at the National Immigrant Justice Center. We're so glad to have such great attendance and interest in this presentation. As I mentioned, we're going to be talking about ICE requirements for warrantless arrests under the Castañon Nava settlement. This presentation is going to be translated live or interpreted live into Spanish. So without further ado, before I say anything more, I'm going to hand it over to Gabby, who is our interpreter, so that she can give folks instructions on joining the interpretation channel.
Thank you, Karen. Hola a todos, buenas tardes. Mi nombre es Gabriela y estaré dando instrucciones sobre cómo usar la función de interpretación simultánea para crear un espacio bilingüe en inglés y en español. Voy a dar estas instrucciones completamente en español, luego las voy a repetir en inglés y después comenzaremos. Hi everyone, my name is Gabriela and I'll be supporting with English and Spanish interpretation today. I'm going to give the instructions on how to use simultaneous interpretation function here on Zoom to create a bilingual space in English and in Spanish. I'm going to give these instructions entirely in Spanish and then I'm going to repeat them in English and we can begin. En unos momentos, cuando termine de dar instrucciones, vamos a activar la función de interpretación y un nuevo botón va a aparecer en sus pantallas. Todas las personas tienen que seleccionar su canal de preferencia con excepción de las personas completamente bilingües en inglés y en español. En este caso no tienen que seleccionar ningún canal. Si están conectándose desde sus computadoras, van a ver un botón de un globo terráqueo en la esquina inferior derecha. Le dan clic ahí y luego en su canal de preferencia entre inglés y español. Si están conectándose desde sus celulares usando la aplicación de Zoom, son los tres puntitos abajo que dice More o Más y luego del menú que aparezca, seleccionen Interpretación de idiomas o Language Interpretation y luego su canal de menú que aparece, por favor escojan entre inglés y español. Finalmente, no olviden presionar el icono en la esquina a mano derecha, arriba donde dice Done o Listo para que se active la función. Por favor, todos les recordamos hablar alto, claro, a un paso moderado, evitar el Spanglish y los acrónimos si es posible. Y si necesitamos pedir ayuda para que hablen más despacio o algo más, lo voy a escribir en el chat. Por favor, manténganse al tanto. Si tienen dificultades técnicas, no sufren en silencio y háganos saber para que alguien los pueda ayudar. Gracias. Voy a repetir estas instrucciones en inglés y después comenzaremos. All right, everybody, in a moment, when I finish giving these directions, we'll activate the interpretation feature and a new icon is going to appear on your screens. All people have to select their preferred channel with the exception of people who are fully bilingual in English and in Spanish, in which case they do not have to select any channel. If you're connecting on your computers, you will see the icon of a globe on the right bottom corner. You click there and then select the channel of preference between English and Spanish. If you're joining from your cell phone using the Zoom application, click on the three dots at the bottom where it says More. A menu will appear where you can select language interpretation, your preference between English and Spanish, and finally make sure to hit Done for the function to be activated. We want to remind everyone speaking, particularly our panelists today, to please speak loud, clear, and at a moderate pace. Avoid Spanglish and acronyms if ever possible, and speak one person at a time. If we need your support by speaking slowly or anything else, I will drop it in the chat box, so please stay alert to messages from me. If you have any technical difficulties, do not suffer in silence. Let us know that so that someone can support. And thank you. We can go ahead and start off. Ahora podemos comenzar.
Karen, you're muted.
Great. Thank you so much, Gabby. And everyone should now see the interpretation button at the bottom of the screen if you need to use that. Again, my name is Karen. This presentation is about the enforcement of the Castañon Nava settlement, which addresses vehicle and warrantless arrests in the Chicago area of responsibility, which is a 6-state region. A couple more housekeeping things before we move on. The first of which is that this is a large group. There are already more than 320 folks in this meeting, and we expect there to be even more than that. So for that reason, after we're going to turn off the chat function, but if you are welcome to put questions in the Q&A box, and we will try to answer them simultaneously and save some time at the end for additional just dialogue with respect to the questions, including at the end, we will have some hypothetical hypothetical situations that we will go through, and at that time, we will turn on the Q&A so that people can respond with what they think the correct answer is to the hypos. Okay. So this in the next slide, I'm going to give you this is an overview of what we're going to cover in this presentation. We're going to cover the Castañon Nava litigation and how we got here. We're going to talk about the key requirements that the policy, the policy that originates from the settlement requires, and discuss some of the documentation required, discuss remedies that might be available to folks who experience a policy violation, and then, as I mentioned, discuss some practice hypotheticals. So I'm going to start us off by talking about a history of the case that we're talking about. In May of 2018, the NIJC, along with the law firm Winston and Strawn and two organizations, the Illinois Coalition for Immigrant and Refugee Rights and Organized Communities Against Deportations, along with 5 individuals, filed a lawsuit against ICE, challenging a warrantless arrest enforcement operation. I want to note that the operation at that time, Tom Homan was the director of ICE, and he was sort of the person who was spearheading that operation. You might be hearing Tom Homan's name and think that, why does that sound familiar? And that's because Tom Homan has been proclaimed to be President Trump's incoming border czar. And even though we're near the border here in Chicago, it seems to be that Tom Homan is preparing us for a lot of internal enforcement. And even though his supposed title will relate to the border, he intends to take on actions that implicate the interior of the United States as well. So a lot of the things that Mr. Homan said in the first Trump administration that led to us filing this lawsuit in 2018 are exactly the same kinds of things that he is saying right now, including things like people should be looking over their shoulders, and that he intends for immigration to go into cities and make big community arrests, and that he's using the word collateral, which to refer to people who are in the vicinity of people who are otherwise who might be a target of an enforcement action. We'll talk more about collateral arrests later, but basically what I'm trying to communicate is that the reason we're having this training is because the thing that caused us to sue in 2018, we are on the cusp of possibly seeing it happen again. And we entered into a settlement agreement at the end of that case that took effect in 2022. And through that settlement agreement, which is in place until May of this year, there should be some limits and legal limits on what ICE is allowed, ICE being Immigration, Customs, and Enforcement, what immigration is allowed to do, particularly within the 6-state region that the settlement covers. Apologies, the slides are a tiny bit delayed. Okay, so I've mentioned a couple of times now the 6-state region that the settlement covers. The settlement covers all states in what's called the Chicago area of responsibility. Even though that name references Chicago, it includes Wisconsin, Illinois, Indiana, Kentucky, Missouri, and Kansas. So if you are a person who encounters immigration and undertaking a warrantless arrest in one of those places, there might be certain remedies that the person who gets arrested might be a member of the class, and that person might be entitled to certain remedies under the settlement. Before we move on to discussing what the settlement entails, I want to let you know that there are many resources about this case on NIJC's website. This is a link to our website. The website is available in English and Spanish, and you'll see on the side here all of these different items, including the warrantless arrest policy, the national policy that is a result of the settlement. The settlement agreement is there. There's a FAQ form, like a fact sheet that you can take out into the community if you are doing this work in the community. And then importantly, very importantly, there is a button on the screen and it shows you how to make a referral to us if you think that you have experienced a violation. Later in the presentation, we will do a demo of how to actually do one of those referrals on the spot. And with that, I think I'm going to pass it to my colleague, Mark, who will talk to you about the settlement itself.
Yes, hi everyone. I'm Mark Fleming. I'm the Associate Director of Litigation. I was one of the lead attorneys on this case, and I think we were remiss in not mentioning also that the ACLU of Illinois was co-counsel on this case as well. As you can see on the slide deck right now, this is the nationwide policy. Those are the pages that come from the settlement agreement that are on that page that Karen just mentioned on NIJC's website, and we will be pushing a lot of this information out to our other allied organizations. But those are the specific details of the policy. As Karen mentioned, it is a nationwide policy. However, the remedies that we have been able to establish here are only as to the 6-state region. So that is Illinois, Wisconsin, Indiana, Kentucky, Kansas, and Missouri. So the ability to, one, seek release for individuals, seek remedial measures against immigration officers that violate the policy, and frankly, as we face potential mass enforcement in the coming days and weeks, the more violations that we are able to identify, we are able to seek further remedies from the court. We'll be going back to our website again a little later. The only other thing I was going to flag from the website is, in addition to the fact sheet itself, on the back end of the fact sheet includes also a referral form that you can also manually fill out and submit to us by email. And the instructions are on that form, both in English and Spanish. Next slide. So again, what we are talking about are warrantless arrests. And I think the key thing to flag here is when we say warrantless arrests, this also includes administrative warrants. These are the civil immigration warrants that immigration officers seek from their supervisors typically. And there's two key ones here. The one on the left is what's called the I-200 warrant of arrest. That one, on the left, yes. And that one is typically when someone is arrested prior to their removal proceedings. So it is at the point of arrest at the start of removal processing. The one on the right is what's called the Form I-205, which is a warrant of removal. And this is the typical warrant, administrative warrant, again, that's not issued by a judge. That is when somebody has an outstanding or prior order of removal. The next slide. And then this is the judicial warrant. And this is the one that comes into effect, particularly when ICE may have permission to enter a home. And so I just want to flag that when we're talking about this policy, when we say warrantless arrest, it means that they do not have any of these three. Now, recall from Know Your Rights presentations, obviously, the warrants on the prior page, the I-200 and the I-205, do not permit ICE to enter a home without consent to enter, whereas the judicial warrant would allow them to enter a home. But again, this Nava policy and the remedies we're talking about is in the instance where they do not have any of these forms of warrants. Next slide. So under the policy, and again, under the statute, ICE officers, when making a warrantless arrest, so one without an administrative warrant, they need to have probable cause that the individual is in the United States, is a non-citizen, and in the United States in violation of the immigration laws. And in order to make a warrantless arrest, they need to have probable cause that the individual is likely to escape before a warrant can be obtained. And at the bottom there, you see what probable cause generally requires. It requires a reasonable grounds for these conclusions. And the policy addresses, and this is important, the policy addresses what sorts of information ICE needs to be considering, but also documenting when they make a probable cause finding, not only that the person is removable, but likely to escape before a warrant can be obtained. And we're going to get into what does that mean, likely to escape before a warrant can be obtained. This next slide, this is about the timing and scope of when they need to be making those probable cause requirements. ICE must conduct the determination at the time of the warrantless arrest. So they can't backfill it with information that they gather after the arrest. This is at a point of arrest analysis. And this analysis is required for all warrantless arrests, whether the person is a target of enforcement or is a quote unquote collateral arrest. And this is an important feature because what we've seen in immigration enforcement actions, particularly when they go into the community, they will often have a handful of targeted individuals. And these will tend to be individuals that have a prior order of removal that they then have a warrant of removal for. So that form I-205. As to that individual, they fall outside of the Castañon Nava settlement. However, they use those targeted individuals as the pretext to get into the community to then sweep up everyone else that they encounter. So these are going to be quote unquote collateral arrests. These are the individuals that ICE encounters who were unknown to ICE and not on their radar for enforcement until the encounter occurred when they were out in the community. And the last thing on the timing and scope, ICE officers must comply with these requirements, even if they subsequently issue an administrative warrant when they're processing the individual. And so I think some folks may know that when someone is processed into immigration, they often issue an administrative warrant as the basis for their detention as the removal proceedings start. That administrative warrant will not cure the violation of the Nava settlement. Next slide. So under the policy, in order for an ICE officer to determine whether they have probable cause that the individual is likely to escape without a warrant before a warrant could be obtained, and again, we are talking about one of those administrative warrants, so it's very easy for them to get it. And so we would argue, in any enforcement action, that the bar is very low as to or very high as to what they need in order to establish probable cause. But it is a totality of the circumstances test. Now, we fought with opposing counsel in negotiations over and over about this, but where the policy ultimately landed is one, that there can be no single factor. They must consider the circumstances holistically in what they're observing at the time of the encounter. And frankly, there is no precise list of factors. However, as you will see, the policy does require them to consider some very specific factors and documentation of those factors. So some of the relevant factors, and these again are in the policy itself, and again require ICE to document after the arrest, is one, was the officer able to identify the individual? And this can obviously cut both ways. If they are able to identify them because they provided identification, these sorts of things, that obviously cuts against the notion that they are likely to escape. Knowledge of whether the individual has previously tried to escape or evade immigration officers. Now, obviously, this cuts both ways again. If they do have that sort of information, that probably leads towards probable cause. Whereas if they don't have that information, then it cuts against a finding of probable cause. The third one is whether there was an attempt to flee, particularly when the ICE officers encountered the individual. But the one I want to focus on the most, and you can see is highlighted, is ties to the community. ICE has conceded in the policy as a statement of law that when an individual has ties to the community, such as family, longtime resident, stable home where they've lived for a long time, stable employment, church, community, membership in a church, and other community ties, that these factors cut against a finding of probable cause that the person would escape. Because the notion is if the person has long ties, for example, kids who are U.S. citizens, in a home that they lived in for the last 20 years, these are all instances in which ICE could go back, get a warrant, and come back out and make the arrest if they so choose. And then the last is just a catch-all that's in both the policy and on here, and that needs to be documented, is whether there are other circumstances particular to a specific arrest that cuts either for or against probable cause. Couple things, very important ones. And again, these are statements of law and policy. And thus, while the policy lasts till May, we will continue to push forward litigation to ensure that these protections continue beyond there. The first one is a very important one. Mere presence in the United States in violation of U.S. immigration laws is not sufficient to conclude that an individual is likely to escape before a warrant can be obtained. Again, that is not just in this PowerPoint, it is in ICE's policy, that specific statement. And then, as I said, whether an individual has a known residence, immediate family members that they live with or care for, employment, and other relevant ties to the community, these are all relevant factors that ICE must consider when making a probable cause determination as to whether the person might escape or flee before they could make an arrest on a warrant or before they could obtain the warrant. Next slide. This probably goes without saying. If ICE officer determines that the non-citizen is not likely to escape before a warrant can be obtained, they cannot make the arrest. And again, this is particularly relevant in the context of collateral arrests, unknown individuals that are randomly encountered by ICE when doing large-scale enforcement in communities. And so this is the piece we want to vigilantly, monitor here, but also in seek enforcement and protections from through the settlement. The second one is what's going to lead into what maybe the core requirement of this policy. If the officer makes a warrantless arrest, so makes that determination that they have probable cause that the individual was likely to escape before a warrant can be obtained, that sets in motion some very specific documentation requirements that ICE must make in what's called the Form I-213, which is, think of it as the comparable to a police record form. And we'll show you an example of what it is, but the type of arrest report that you might see in the criminal context. And we'll show an I-213 in 1 second. Can you go back 1 slide? We're not there yet. So after making a warrantless arrest under the policy, an immigration officer, an ICE officer, must promptly document the facts and circumstances surrounding the warrantless arrest in the narrative section of the Form I-213. And as you just saw on the page, on the next slide is going to be an example of it. I think one thing that very important to keep in mind as we monitor for this, and this is more going to be a responsibility on our end, but that documentation is not just as to the likelihood to escape prong, but again, as we talked about, they need to have probable cause that the individual is a non-citizen and removable. And at least in our experience, ICE is not very good at actually making those individualized determinations and documenting them. And so that is an aspect of this that we will be looking closely at. But in addition, under the policy, there's some very specific requirements as to how to document the probable cause of likelihood to escape. In that next bullet, ICE must do it as soon as possible and accurately as possible reflect that determination. Information learned post-arrest relevant to, say, determining custody going forward must be documented separately. That cannot be the basis for the warrantless arrest. And again, subsequent issuance of an administrative warrant, which often happens in the processing of an individual, does not relieve the ICE officer from completing the documentation and requirements for a warrantless arrest. Next slide. These are the first 2 pages of an example of an I-213. One of the things I will flag right now that I answered in a Q&A question is we will be putting this slide deck in English and Spanish on our website and push it out to our allies as well. So you will have it, because I recognize that seeing these slides, especially with the side-by-side, can be difficult. But I just want to flag a couple features of these that maybe how you can identify it is an I-213. One, you will see on the left page there, there's a lot of biographical questions of the individual at the top. The colored out or the redacted is a photo of the individual, just so you have a sense. And then on page 2, which is usually where you start to see the narrative and where this documentation would need to happen, if you look in the upper right corner, it will say an I-213, and then the various pages being listed, in succession at the bottom. But this is where we would anticipate finding that documentation. Next slide. So these are the things that they must document when making a warrantless arrest. And I emphasize it because let's just say they have actual probable cause, but don't document it. We have an enforcement action there to get the individual released and seek further measures against the government. And so this documentation requirement, and a lot of that responsibility is going to fall to us as class counsel because it can be difficult to get a form I-213. But this information, if not documented, can form the basis of seeking somebody's release. So the first one is that the citizen was arrested, or the non-citizen was arrested without a warrant. 2, they need to specify the location of arrest. And so listing out a place of business, residence, a vehicle, or public area. 3, whether the non-citizen was an employee of the business if they were arrested at a business, or whether the non-citizen is a resident of the residence if arrested at a residential location. 4, requiring them to document any community ties that they can figure out at the time of arrest. And so, this may also require them to make this sort of questioning. Obviously, we have other guidance about not answering questions, and we can get into that when we get to the hypos. But again, they need to be documenting whether, they have reason to believe that the individual has family, home, or employment. And then they need to provide specific individualized facts as to why that individual was likely to escape. It cannot be generalized statements. And then the last one, which is really is kind of outside of this webinar, but is important, is that they also need to, and is part of the policy, is that at the time of arrest, the immigration officer needs to identify themselves as an immigration officer, explain that the individual is under arrest, and the basis for the arrest. And that also, one, needs to happen, but also needs to be documented. Next slide. I will go quickly on these. With respect to likelihood to escape analysis and vehicle stops, under the Castañon Nava, what occurred multiple times is individuals were in vehicles, they got stopped with no basis for the stop that then led to warrantless arrests. And so this policy tends to be more focused as to individuals who get warrantlessly arrested through a vehicle stop. But a couple key points here. One, that the ICE officers, that they lack authority, and this is true as a matter of law, not just a matter of this policy, they lack the authority to enforce state or local vehicle and traffic laws. And so under the policy, the ICE officer is prohibited from stating to a driver or other occupant of a vehicle that the reason for the stop is related to a vehicle or traffic violation. And this was a very common feature of these 2018 raids in Chicago and other sanctuary jurisdictions. Next slide. So as to all vehicle stops to enforce civil immigration laws, it requires specific articulable facts that reasonably warrant suspicion that the vehicle contains a non-citizen who may be illegally in the United States. So again, they must have a reasonable suspicion, which is lower than probable cause. However, it still needs to be specific and particularized as to the reason why they have reason to believe that a person is in the car who is not in the country lawfully. Factors that may warrant reasonable suspicion to make vehicle stops near the border may not be the same as would warrant reasonable suspicion in the interior. And in particular, I flag that because a lot of the cases or enforcement of this has occurred along the border in which courts have allowed mainly Border Patrol to look to external factors like the environment, the road they're on, factors about the car that led them to have reasonable suspicion. Now, obviously, if somebody's in a part of Chicago, none of those factors would rise to reasonable suspicion that there is an undocumented or otherwise removable non-citizen in the car. And so we want to be looking closely at this factor if we start to see vehicle stops, because it seems pretty difficult for them, barring knowing about someone in advance, having a photo or administrative warrant, and knowing the person's address. It seems hard to imagine them having reasonable suspicion to pull a car over. Next slide. So under the policy, in addition, especially if it's a warrantless arrest, in addition to the specific documentation of the warrantless arrest, they also need to document the reasonable suspicion for the vehicle stop in the first place. And as I mentioned, it needs to be specific, articulable facts as to why they thought prior to the stop. So not something that they can backfill once the stop has occurred, but factors that prior to the stop form the basis of their reasonable suspicion that somebody in the vehicle was a non-citizen who was removable. Next slide. So for individuals arrested by immigration, by ICE, without a warrant, and again, administrative warrants, within the ICE Chicago field office, this is the Illinois, Indiana, Kansas, Kentucky, Missouri, and Wisconsin area, they may be entitled release under the policy. And again, it's important to mention that if the ICE officer does not document all of this information, that is a violation of the policy. And in addition to release for the individual, which obviously would slow down any efforts by the incoming administration to summarily remove people, officers who violate the policy must be subject to remedial measures by ICE, and that those measures must be reported out to class counsel. And then, very importantly, given what we're facing, if there is substantial and repeated material violations, we can go to the court to seek many more other equitable remedies if we see systemic violations of the policy. Next slide. So this is a screenshot of the fact sheet in screening and referral form. You'll find these. The one on the left is the front page of the fact sheet, and the two on the right is the English and Spanish version of the paper version of the types of information that we need to obtain in order to figure out whether there may be a violation. Again, you can use the paper form here, but we want to then go to the website and show you that there is a way to do it online as well. Karen, do you want to?
Before we, I'm going to navigate us to the page so that people can see this page before we jump into the hypos. But as I'm doing that navigation, I'm going to lift up 2 questions from the chat, Mark, in the hopes that you can answer them live. So the first one, I see that you're in the answering. Is it possible that we'll see the process of getting a judicial warrant become quicker? And do administrative warrants allow ICE to detain people? If you can share answers out to both of those, that would be great. You're muted, Mark.
As to judicial warrants, at the moment, I am very skeptical that they will ever be able to operationalize getting judicial warrants. The reason I say that is there is no process within the immigration system, so the civil immigration system, to get warrants from immigration judges. And again, like, this is, to be clear, this is the only form of arrest in the United States where a judge is not involved either before or after the arrest. So just put a pin in that. But there is no process for getting a judge warrant through like an immigration judge. As to a federal judge, I mean, there's huge logistical problems with getting that. Now, I could imagine them getting judicial warrants to enter, say, work sites. Like, we've seen that in the past when they do large scale work site enforcement. There is really no process and no precedent for getting judicial warrants from federal judges, so from traditional federal courts, for civil immigration violations. And arguably, there is no authority for federal judges to be issuing warrants for civil arrests. I guess conceptually it could happen. It seems very unlikely for them to be able to do it at any scale. The other question with respect to administrative warrants, if they do have an administrative warrant for an individual and make an arrest, that it falls outside of this settlement, because this settlement is only about warrantless arrests. However, and they are lawfully able to make those arrests in certain locations, mainly public locations. I will flag that if they have an administrative warrant, and this is part of traditional KYR, that does, even though they have the administrative warrant and it gives them authority to make the arrest, it does not give them the authority to enter a person's home, the immediate outside of their home, or a private section of a business, or other private locations without a judicial warrant to make that entry or consent to enter that space.
So two more from the chat, Mark, and then I'll do a demo of our website. What happens if there's a sobriety checkpoint? And how does this interact with people who might come across those checkpoints? And then the second one is how are people in the community supposed to know if the form is filled out correctly, especially if the person doesn't get the form?
So two things, and we'll get to, so as to the sobriety checkpoint. Now remember, a sobriety checkpoint is going to be state and local law enforcement agents. If they've been deputized to do immigration, the policy definitely comes in to the extent that they are trying to also do enforcement, and thus they would be required to follow the policy. And that's what I think some folks on here may know as a 287G agreement. As to, say, for example, a sobriety checkpoint where they're in cahoots with ICE, ICE would still be required in that instance to do this analysis and documentation. With respect to the second question of how are we going to know whether they document or not, I think the key part here is to gather the information that we are requesting, and in particular, things that we are going to be looking for on our end. You may not be able to know whether they've documented correctly. In most circumstances, it can be difficult to get the I-213. However, we are intending to enforce this rather aggressively. And so, for example, let's say somebody gets arrested in their home. They provide identification that shows both their name and that they live at that address, and there's no other questions. We're going to take that as a potential violation, and we are going to confront the government that there's a potential violation. And through that meet and confer that we do on the class counsel side, we will be seeking either from the government or from the court that they produce the I-213. So that's the way we are intending to do it. I will flag that under the settlement as to individuals that live in the Chicagoland area, so kind of the upper third of Illinois, there is affirmative reporting requirements under the policy, and I can get into separately why it's only that portion. But in any event, there is as to that people that may get arrested in the Chicagoland area, there may be another mechanism by which we can expeditiously get the I-213.
All right. In the interest of time, can you see our website on your screens now? Are you able to see
I can.
Yes.
Okay,
Yes.
great. Thank you. Okay, so I just want to show you, this is NIJC's website, and also, as Mark mentioned, our partners in this litigation, ICER, OCAD, ACLU, are free to and probably will be putting up these kinds of information on their websites as well. So hopefully you will have multiple opportunities for where you can go to get this stuff. But I'm just going to click through on the button to show you how to make a referral to us, because that will be the most important and the most urgent thing to do. This page is available in English and Spanish. If you see over here to the right, you can click to toggle between English and Spanish if you want to see the questions in English or Spanish. Most of the questions are basic about the person's identity and information and about the circumstances that led to their arrest. If you don't know things, it's okay. Just fill it out to the best of your ability. And if it's listed as a required question and you don't know, just say I don't know. Just type in the box I don't know. And as Mark mentioned, if you are unable to fill this out on a website like this, you can also, back on our website, I'll show you, you can also see this same thing as a printed out document. It's at the back of our fact sheet. So you can just print this page out and you can write in it by hand, or you can print it, you can download it and type into it if you want. And you can email it to us. The email address where you would send it is litigation@immigrantjustice.org, and we can put that in the chat. And without any further ado, I want to hand it over to Shanat to do some hypotheticals.
Hi, yes, I'm Shanat. I'm with Organized Communities Against Deportations, OCAD. And so we have 3 hypotheticals with 3 questions. We're going to open, I believe, the chat so you can all add your answers, and then Mark and Karen can clarify, do the observations on the answers. So the first hypothetical has to do with a home encounter. ICE coming to our home. This is the story of Juan, who was born in Mexico, who has lived in the United States for more than a decade. He is single, but his 4 siblings all live in the United States, including his youngest sister, who is a US citizen. Juan lives in a home in Cicero, Illinois, with 5 other men, all of whom are Latinos. He does not know if these men have immigration status, and he has not shared any information with them about his own immigration status. He is undocumented. 3 police vehicles arrive at the home that Juan shares with his roommates. The vehicles are unmarked, black SUVs. 6 officers wearing bulletproof vests. Some of the come to the door of the home and ask to come inside to ask a few questions that would assist the officers' investigation into recent break-ins in the neighborhood. The officers' vests say police on them, but do not say ICE. The officers are wearing shirts that indicate that they work with immigration, Department of Homeland Security, but that shirt is covered by the vest. One of Juan's roommates lets the officers come inside. After rounding up all the people in the living room, one of the officers asks to speak to Felipe, who is one of Juan's roommates. Felipe is not at home, so Juan tells the officers that Felipe is not there. The officers then assist each other in the living room to insist that they tell them their name and provide photo identification to them. Juan produces his Illinois driver's license, which he qualifies for, even though he is undocumented, and at least one person produced a matricula, or consular ID. The officers also ask no further questions, and neither Juan nor his roommates provide any additional information. After inspecting Juan and his roommate's ID, the officers arrest everyone in the home and take them to custody without saying anything further. So the questions we would like you all to answer. Does this action violate policy? Does the answer to the question change if Felipe is home? If Felipe were home, the officers only arrested him on the basis that he has a prior removal order, would that have been a settlement violation? So we'll give it a minute and see if we get some answers. And we're seeing multiple yeses. It violates the policy. All yeses. One no, thinking that they allowed the officers inside. No to number 2, but yes to everything else. So I don't know if Karen or Mark, if you want to speak to it.
So Mark, what do you think about the fact that they let them come inside? Does that make this does that change things?
It does. It does not, as far as the Nava policy, because again, that piece is only as to warrantless arrests and vehicle stops. However, I think, as a lot of people pointed out, it's probably a bad idea just to let them in. They needed a judicial warrant to get in. Now, obviously, they presented a ruse to get in. And so it presents another problem, but that piece is not a violation of the policy. As to but I guess the big but is yes, this is a violation of the policy on the back end, which is they did provide some identification. The ICE officers did not ask any other questions. So remember, there were those 6 questions as to the likelihood to escape that they should have been asking, that they didn't. And then more also, when they made the arrest, remember, under the policy, they need to be identifying themselves who they are, that the people are under arrest, and providing the reason for the arrest. And so this goes to that question in the chat about how are we going to know whether they document it or not? This is a scenario where, very likely it's a violation. And we would, once we get the information, we would be fighting aggressively to get the I-213 because we have enough to go on here to say there's likely a violation. And I think one of the important things to keep in mind about these hypos, it is not your responsibility to determine whether there's a violation or not. We're much more just trying to provide a sense of what might be violations. But again, it's really about providing the information in the form, providing contact information so that we can follow up to gather more information if needed.
Sounds good. We'll move to hypothetical number 2, and this is in the workplace.
Should we
Christina?
mention that one thing to flag is it would not change if Felipe had been there. Again, and if Felipe had a prior removal order, it's entirely possible that for Felipe, there was no violation of the policy. But again, they should not have let the officers in the house in the first place. But as to the other individuals, and particularly Juan, it likely was a violation.
Sounds good. Let's go to workplace encounter. Cristina works at a large food processing plant in Kansas. She is one of hundreds of workers at the plant that employs for each shift. When she applied for the job, she provided a fake social security number. Cristina knows that there are many immigrants working at the processing plant and that many of them provide fake documents or made up social security numbers to get hired at the plant. On March 31st, 2025, dozens of immigration vehicles arrived at the plant. On that same day, Cristina was training a brand new employee, Alex, who is working his very first shift. While they were getting to know each other, Alex shared with Cristina that, like her, he's undocumented. The officers who show up at the plant appear to have documents authorizing the arrest of many employees, including people who are not working that shift. They do not, however, have any documents that name Alex in particular because they created their documents before he started working there. Officers arrest Cristina, Alex, and everyone else in the facility without asking them any questions apart from their names. So the questions: was this warrantless arrest of Cristina? What about Alex? Was it Nava policy violation for ICE to arrest Cristina? What about Alex? Does the answer change if the officers speak directly to each person they're arresting, and gather information from them? First answer, there's folks are saying yes, and no to Cristina.
Sorry, I was trying to answer some of the questions in the Q&A, and then I couldn't find my screen. Most likely it is not a violation as to Cristina because it sounds as if they may have had an administrative warrant for her arrest because they had documents authorizing arrests. It would kind of depend on what those are. I will flag this hypothetical is a bit counterfactual in the sense that in traditional experience, ICE has never had a list of people whom they already had warrants for their arrest at the time of worksite enforcement. So I don't want to suggest that that is something that's common. As to Alex, absolutely, it's a violation.
Mark, can you answer how can they get into a private business without a judicial warrant?
They traditionally do need a judicial warrant to get into a private business unless the business owner or some other authority at the business lets them in. I don't want to get too technical, but there's a long-standing warrant that they can get, a judicial warrant called a Blackie's warrant, which is named after a restaurant in Washington, D.C. from the early 1980s. But there is, yes, as to a business, especially if they're in the private areas of the business, they would need a judicial warrant to get there. But again, that piece of it is not part of this settlement. We would be focused on, okay, once they're in the business, if they're making warrantless arrests, are there violations?
Mhm.
So,
The final, oh,
sorry,
go ahead,
one
Alexia.
question from the chat. What if somebody has a pending, this is a question. Is ICE able to arrest a person if the person has their social security card, a work permit, and also is in process of applying for relief? The relief mentioned in the question is residency.
It is going to depend on exactly what they have, but again, that would fall to the part of, remember, the policy requires them to document the probable cause that the person is removable from the United States, as in addition to this likelihood to escape. And so it's entirely possible that in addition to a violation of this policy, that it could possibly be a violation generally that they have no authority to make an arrest of that person at all.
Great. Last one.
Yes. The last one is with a vehicle. So Jorge owns a pickup truck that he uses for work and personally. Jorge is from El Salvador and has a removal order after missing a hearing in 2005. In 2022, Jorge was stopped by police for a driving violation in the truck that he still owns. He was briefly taken into custody, but then released and ordered to pay a fine, which he did. Though the pickup truck is registered to Jorge and belongs to him, he routinely loans it to his cousin Sergio, who is undocumented. Sergio is 2 years younger than Jorge. On March 2nd, 2025, Sergio is driving Felipe's truck with his girlfriend Maria. They are running errands when Sergio gets pulled over after passing through an intersection after exiting the parking lot of a grocery store. The car that pulls Sergio over is unmarked. The officers are wearing vests that say police, but that do not mention ICE. And another car pulls in front of the truck, blocking Sergio and Maria in. That car is also not marked. Two officers approach the truck. One says that they stopped the car because the taillights was not working. That same officers asked to see identification for both Sergio and Maria. Sergio provides his Illinois temporary driver's license but refuses to answer any questions. Maria, who has a pending new visa case, refused to share her documentation because she believes the officer has no basis to inquire about her identity. She also refuses to answer any questions. The officers take both Sergio and Maria into custody. The first question, was it permissible for ICE officers to pull over the car? Was it permissible for the officers to take Sergio and Maria into custody? And if either Sergio or Maria had volunteered additional information about themselves in response to questions, would it have been permissible for the officers to use that information to take one or both of them into custody? And I'm seeing no, not to the pulling over and taking them into custody. There's no reasonable suspicion. Several no's. And then there's coming in yeses.
So this one is probably a mixed bag and is a maybe on some parts of it, definitely violation on others. So was it permissible for ICE officers to pull over the car? So this is before they said it was for a tail light, and this was a little bit of a trick, but like it's possible that they had an outstanding administrative warrant for removal of the owner of the car. I'm blanking on the Jorge, in which they knew that he had this vehicle and it was registered to this, and they may have seen Sergio, who's roughly the same age, enter the car. It's possible they had reasonable suspicion to pull it over. After that, everything becomes a violation. And again, we only need one violation of the policy in order to seek enforcement. it based on the fact that the officers, at least as far as the hypothetical, really didn't ask any other questions. And they probably, based on the identification of Sergio, really quickly realized that they did not have Jorge. So even if they maybe made the stop under proper pretenses because they were tracking Jorge in his vehicle and trying to stop him in his vehicle, they immediately started to violate it. One, by saying that it was about a taillight violation. Two, once they saw Sergio's identification and realized it wasn't Jorge, they're in a whole other land of warrantless arrest, at which point they're needing to ask the questions about and analyzing whether they're likely to escape before a warrant can be obtained. And that then goes to the last question, which is, it's a bit of a hypothetical, but if Sergio or Maria offered more information, certainly that go to these factors, that would definitely most likely cut against the likelihood to escape before a warrant can be obtained. But this would be a little bit one of those that we would have to decide how aggressively we were going to go into court to seek enforcement. Should we try to answer questions in the chat? I mean, there's quite a few, or in the Q&A.
So what I'm going to say is we scheduled this meeting to end at 5:30, and I'm respectful of everyone's time. Anybody, if you need to leave, you're welcome to go. We will stick around and try our best to answer as many of the questions as we can in the Q&A before we turn off the recording. But you are welcome to leave if you need to go, obviously. So one question is like, I'm a public defender. What should I be looking for, and how will I know if this policy is being followed?
In the context of public defenders, and particularly as your clients, the most likely scenario that you typically see is when someone gets an ICE detainer while they're in custody. And this was in the chat or question as well, while the ICE detainer is not an administrative warrant, they now, as a matter of course, issue an administrative warrant alongside the ICE detainer. And so in most of those circumstances, we would not be seeing violations of this policy if they're in custody of local law enforcement. Where we may see it is in the context of like probation, appointments and things like that. But generally speaking, somebody who is in local custody, pending criminal charges or a criminal arrest, usually ICE interacts at the local level with an ICE detainer, and usually with either an I-200 or an I-205 administrative warrant.
So two related questions. If there are additional violations of the settlement after May of 2025, is there a way to extend the settlement, or will new litigation be required? And if we identify violations after the settlement is over, should we still report them?
The answer is yes, still report them. While the policy, while the settlement expires, there is good arguments to say that the policy should continue beyond it, because again, it is, and it states it, that it is a statement of the law. And so to the extent that a Trump administration tries to rescind the policy, we intend to continue to fight to make sure that these protections move forward. It may require future litigation. It will kind of depend how the next couple months play out, but we are committed to using this in similar tools as, a real harm mitigation attempt at the threatened mass deportation efforts that the incoming administration is describing.
The next question is, given that the settlement only applies to the 6-state region, what should I do if I'm somewhere else?
You should report it. we are in active conversations about bringing very similar litigation elsewhere, and have been in communication with a lot of allied organizations who want to bring copycat litigation. And so we would ask that you still report it. Obviously, on the form, you have to identify where the violation occurred, but that will help us to assess and pass on to other organizations who may be allied in common interest agreements with us to bring companion lawsuits with these sorts of protections in mind.
Okay, next one. If a guy shows up at your home wearing a uniform that says it's police, is it wise to refuse to open the door when we have these cases of police shooting people perceived to resist them?
I mean, I think that without a doubt is a fair concern. I think the general practice, again, is, if they have a warrant, they should be producing it anyway. And so while one could refuse to open the door, I think the first step that is often advised is to ask to see the warrant itself. And that is a reasonable step to take, short of complete refusal at the outset. But again, I think this is a personal decision, but our strong recommendation, especially in the immigration context, is not to open the door because they have no authority to enter absent a judicial warrant.
So there are some questions in here that are related to things like detainers and the possibility of detention camps. Unfortunately, a lot of that is beyond the scope of this training. We can stick around and maybe do some more casual Q&A after that, but I want to flag that I'm skipping those questions because they are not related to this, and I want to record this training and make it available to people who are interested in this specific topic. If there are no other questions, if you're having other questions, please put them in the Q&A and not in the chat. Otherwise I won't see them. And one of them is, could you please repeat the difference between an I-200 and an I-205?
So those legally they are identical. And so the only difference between them, and legally identical means that if ICE encounters someone in a public space, they can use it as a form to make the arrest. The difference between the two is the one on the left, the I-200, is the warrant that is issued against an individual when they enter removal proceedings. So when they get the notice to appear and they are subject to either, detention where they're eligible for bond or mandatory detention, that's the warrant that triggers that authority on the front end of a removal proceeding. The one on the right is what's called the warrant of removal. That's the form I-205. So when, say, an immigration judge orders removal, ICE then, or DHS then, issues this administrative warrant as the basis to bring, especially if they're not in custody, to bring them, to arrest them and bring them into custody to remove them. And so they serve different functions at different points in the immigration system, but legally they have the same powers and legally have the same deficits of power, in the sense that they cannot be used as the basis to enter a home or other private spaces in, say, businesses or other, schools, hospitals, you name it.
Okay, I think that this will be the last question unless I see new ones, which is, can you repeat, for somebody who gets a notice to appear or an NTA after one of these events, what happens next and what is the remedy for them? And can you say what the answer is based on whether they're in Chicago or other parts of the area?
So that's a fair question. So as to the notice of appeal, the remedies that we have currently under the settlement only allow us to seek release. It does not prevent them from issuing a notice to appear and start removal proceedings. However, if the individual is represented, there is opportunities to seek a motion to suppress evidence in the removal proceedings, or a motion to seek termination of the removal proceedings that may be, in part at least, based on violations of the settlement. And we have, I mean, to the extent it comes up, we have some examples of motions like this that we filed, or one we didn't file, related to the named plaintiffs, or plaintiffs that were part of or were swept up during these raids that occurred back in 2018.
All right, I think that is it. Thank you so much for coming. Thank you to Gabby, our interpreter, for all of your hard work. Thank you to the participants. We had a great turnout for this event. Unfortunately, I think that we will be seeing some needs for this information in the next few days potentially. So please do review the materials and visit NIJC's website so that you're ready to make referrals if and when the time comes. And hopefully we can keep our community safe to the best that we all possibly can. Thank you very much for your attendance and have a good rest of your evening.